and welcome to Reportage. This is Danish bin Nabi. In today's segment of Reportage, I shall have a discussion about a recently released book titled Defaulters Paradise Lost, written by Anand Merathia, which has been published by Thomsons and Reuters. The book is a comprehensive explanation of the Insolvency and Bankruptcy Code 2016. It offers a nuanced perspective shaped by authors' practical experience in the legal field. One of the key features of this book is its inability to make the complex nature of the IBC accessible to the common people and a broader audience. More with Mr. Anand. Mr. Anand, IBC seems to be very close to your heart. What I could gather from your book. Explain for the viewers, how did this IBC concept basically evolve?
So IBC is a law, of course, the full form is Insolvency and Bankruptcy Code. To begin with, I think my first opening statement would be that while the name of the law suggests negative, I wouldn't use the word negative, but generally people have believed, insolvency, bankruptcy are to be taken connotation or a context which is not positive. It's actually more for restructuring of companies, giving companies an exit when they are not able to function and do the, I would say, operations in the right manner. Should be doing. Now, so your question, what led to the IBC? Why do we have a law? We'll have to go back a little bit in time. Have to go back a little. So these are the last 20, 25, 30 years. So whenever banks gave loans to companies, and those entities, those corporate entities, those companies not able to pay the loans back, which is ultimately public money, it's your money. So the banks had some mechanisms to go behind these kind of borrowers. You can call them defaulting borrowers, but they had certain mechanisms. But with time, we realized that in the 70s that the borrowers were having I would say, a good right at the cost of the banks and financial institutions. Government came up with a law called the Sick Industries uh, Rehabilitation and Related Act, something like that. And an organization called the Board of Financial Reconstruction was set up, called the BIFR in New Delhi, with a very noble objective that, okay, let's try and rehabilitate companies which are in a sick condition. But all of that ultimately kept taking a lot of time. It was slow. The process was not as transparent as it is in IBC. Ultimately, delays, as Indian legal system is usually tainted for or questioned for. Well, I have a very personal different perspective. To also understand from the judiciary's perspective that people are working day and night. Quantum of litigation in this country is huge. So PIFR didn't prove to be a success. Debt recovery tribunals were slow. The civil courts were fairly slow. Average time taken for a litigation to see some finding or some kind of closure was about 5 to 10 years. Even the winding up regime in the company or in the Companies Act, high courts, where if a company is not capable to repay its debts, you wind up the company, liquidate the assets, and give the monies to whoever the creditors are. Even that would take years. So with all this happening, this was one part of it. The other part of it, why we needed this specific law, IBC. A lot of discussion happens around I would say, performance of insolvency code. But very few times or seldom do people touch upon the reason why we landed up in such a big economic mess in 2015-14. The non-performing assets, NPAs, as banks used to call it, 9 lakh crores, 10 lakh crores, all big numbers. Basically, what was happening is a lot of loans were being given in the previous decade, somewhere starting from the 2000s. And then those loans, as first of all, there were a lot of issues we will discuss that as we go forward. Right from overvaluation of assets, giving loans more than required, hand in glove kind of situations, subsequently the borrower defaulting in it. And then if defaulting, the bank doesn't want to show, I would say that this asset has become or this loan has become a bad loan on 31st March to ensure that the bank balance sheet of the banks don't look odd. So that led to a new concept emerged called evergreening of loans. Same loan you are just going on keeping it alive by giving some additional sanction just to repay the interest, so on and so forth. So all this was happening and it was becoming more of a bubble. So given the, I would say, relatively weaker legal system that we had, and with this mounting issues of I think it was a bold and much required decision, which was the brainchild of the then and Mr. Arun Jaitley, that we should have a comprehensive law where people can't take different kind of remedies in different courts. And therefore, in 2016, we had the enactment of Insolvency Code.
I was coming to this thing. I guess in 2016, as you right now mentioned, it became a law. Explain for the viewers how did basically the government, the BJP government, helped you in making this legislation to see through.
So this law initially, I don't have the specific dates with me, but it was always in discussion. There was a bill passed, there was a bill put forth earlier somewhere in 2000, say 2013, 14. There were committee discussions, they were happening. But then it was in 2016 finally that around May 2016 is when it got the accent of the president, and December 2016 it became effective. So I think the government definitely showed its will to push through a, I would say, strong legislation for the benefit of the banks. Of course, later there has been criticism from different sectors. We can discuss that. But yes, to being your pointed question, what did the government do? Yes, it tried pushing it even earlier, prior to 2000, I would say 16. But then I think it's only when they were completely, when they had their feet on the ground completely in their first term of the regime, they were able to have this enacted.
Any particular government official you are particularly fond of as far as this IBC 2016 legislation is concerned?
So Jaitley was the person as a finance minister at that point in time who did foresee that if we don't take a significant decision or a bold step to clean up the mess that was there, step to the end, possibly the law would not have seen, say, the
Day
day,
of the
but then,
light.
sorry, the day of the light. Uh, but also, since you mentioned uh, about specific official, I think I did mention that there was one Dr. T.K. Vishwanath who was heading the bankruptcy law reforms committee, fairly, a very learned person. Also, being a professor, he was a secretary general of the Sabha. He's a drafts person. He put together this law as well. In fact, he's given an introduction to this, right? So there's an introduction from him. What is his perspective of IBC?
If we talk of politics of this IBC, why did Congress government before 2014, why did they not come up with this concept of IBC?
Well, that is for something, if I can say, that's for the Congress to, I think, people from that regime will be better positioned to answer. But all I can tell you is, and I think,
But is it also
I
related to a strong decision making things, which we see now that this BJP government does have, that they take the bold steps, the strong steps, and they have a decision. Either they are going with it or not, they are not going with it. Was this taking the bold decision lacking in the previous governments?
think that's a matter of public, I mean, discourse. People are aware. There was a very popular term called the analysis paralysis. If I'm not wrong, the previous government. So they would only be analyzing and they would not be able to take decisions. So that's like a given. What you just now mentioned, that's a given where I definitely believe that the present regime, where they see a challenge, they try their best to address it. But as far as the first part of your question, previous regime, did they see the challenge? I would say, and I would leave it for you to decipher the rest. I think somewhere they were also conveniently ignorant about it. They knew this was happening. They knew evergreening of loans were happening. There were a lot of, I would say, loans provided on unrealistic terms and on unrealistic, I would say, valuations at that point in time. So, and I don't think there was any proposal or any effort at that point in time, previous government, uh, the UPA, to even come up with some kind of a comprehensive legislation.
Mr. Anand, explain for the viewers what are the challenges that this IBC is going to face?
So basically, the IBC, while it has been very beneficial as well, it does have some challenges, and it has. I think I should then also cover the advantages, which I will cover later. I will, since you asked what are the challenges of this advantages. Few of them, if I may say, to begin with. See, people are judging the success of IBC on one main parameter of how much recovery percentage have the banks got. In my personal and humble opinion, to begin with, as Supreme Court has said multiple times, that the purpose of this law is not to recovery or not to recover money, but also resolution of distressed companies and assets. So marking it on that parameter and saying that no, banks are only getting 30% or 32% of the total or claimed amount. That is, to begin with, I would say, a wrong perception. I won't call it a challenge, but that's a perception which people need to understand realistically. Also, the claims that have been filed for about 9 lakh crores, against which about 3 lakh crores have been recovered approximately. Uh, a lot of those claims are, I will not use the word inflated, but they top up all the interest, penal interest, and all possible costs, which would have otherwise also got waived off in, let's say, a one-time settlement offer outside IBC, which would have been a private treaty. It would just not have come in light of people transparency. Challenge perspective, infrastructure is something which needs to improve. I think the law picked up initially quite well. Of course, there was a dip in COVID. But surprisingly, as you know, the Indian economy has done extremely well post-COVID. I have seen on the ground, we are seeing situations where companies which were at the brink of insolvency in let's say December 2019, January, today they have become resolution applicants. They are the ones who are acquiring companies. So definitely the number of admission cases have gone down, which is a good sign. So coming back to pendency of cases, you need more infrastructure, more benches, more judges, some kind of a system to ensure that cases are, see, you cannot stop people from coming to the courts. Litigations will happen, but some way where frivolous litigations can be penalized more. I think we are heading towards now more complex issues such as cross-border insolvency, group insolvency, how to connect the personal insolvency of an individual who's a promoter of the company with a corporate insolvency. Those are going to be interesting areas which have to evolve and develop.
Talking of these challenges or talking of these perceptions which we have, how can we overcome these perceptions or challenges?
So to begin with, I think on the first aspect with respect to recovery, I think I already touched upon it. I'll give you a simple example, Satanish. Somewhere, let's say in 2004 or 5, you had an asset which is worth 100 rupees. You get a valuation done for 500 rupees, showing that it is 500 or 400 rupees. And you get a loan sanction against that for, let's say, 250 rupees. You convert all this into crores, just imagine the magnitude. So you need only 100, but you have already got in 250. So in your business, you may or may not put 100 for the additional 150. And of course, it was a complete system that was in place. Everybody benefited out of it. So it was happening. In that 150 rupees extra, what will the promoter do? Either they will over leverage, play the game beyond what they should have played, or sometimes park the money in offshore jurisdiction for whatever, some rainy day or some bad day. So things of that nature were happening. So therefore, to begin with, the valuation itself was high. So the due diligence at the time of giving the loan was not done very well, which led to this whole bubble of assets being less, values and claims being more. So I think one aspect is, and banks have started realizing, is that they do more due diligence today when they give the loans. They have to do it. They cannot just continue with the old format. This is one of the issues. Then you mentioned about other perspectives, other challenges. Of course, if there are going to be more benches, additional, more and more judges who can hear these cases, that will definitely help. And more awareness for the public also, because a lot of time people tend to complain that on various parameters, but need to have a holistic understanding for you to be able to appreciate as to if there is a challenge or if there is a concern, why it is so.
Mr. Anand, if I'm not wrong, you come from a legal background. And this book, and I have seen many people, they are afraid of these legal terms, legal readings, and legal books. How difficult for you was to make this book as simplified for the readers rather, without putting all these legal jargons into the book, so that the common people could understand what basically this IBC 2016 is.
So that was one of our huge challenges, definitely. See, when I started writing this book, so I was very clear to begin with from day one that the book, the final, I would say, end result, which you're holding in your hands right, that should be something which a non-lawyer should be able to comfortable to begin with. That was something which was not negotiable and very. See, the general perception that we've seen over the years, over the last, let's say, decades together, is that legal books are very, heavy duty, very voluminous, and the jargons are very different. Whatever you mentioned, all of that, and they're very heavy and voluminous also.
And this book is
So
also physically heavy,
this book is physically heavy,
just like
but
any other legal book.
no, then you have not seen legal books. Then I think you should go and see. You should go and get into the
I
library of
have
one of the
another book
lawyers.
in my hand. I hold both the books. This is more lighter than this one.
Okay, that could be something on a, I would say, on the lighter sense. I would take it as a that it's a heavier book on in the positive manner. But compared to typically legal commentaries and heavier books, for the common man, see the point is for the common man. I won't even common man becomes really interesting, but let's say for the banker, for a company secretary, for a chartered accountant, for a student, for a journalist such as yourself, somebody who's interested in economics and commerce in the country, we were very clear that we wanted to break down all these concepts, all the legal issues in simplified language. It took us time. That's the reason it took 3.5 years. For a lawyer, it's easier for me to write a very heavy comment, loaded with a lot of case laws and all of that, because that comes naturally to us. But then to simplify it every time, refining it, cutting it down, making it brief, that is where the challenge is.
My last question before I end up this: what do you suggest for a journalist like me who is afraid of reading all these law books, but at the same time, a journalist needs to learn what the law for a particular thing says? What now you have become an author yourself, you have authored a book. What do you suggest a person like me to do so that we could understand the law books in a nuanced manner?
Fair enough. So I think the best thing there would be is to, at least in this book, I can speak about my book. So what we've done is, if you take the book, there are about the chapters that are there. The first, I would say, about 4 chapters are a complete introduction into the code, and you don't need to be a lawyer, you don't need to have any kind of background with respect to this law. It talks about exactly the previous regimes, the impact of this law, the new ecosystem and framework created, and the key stakeholders. I think that is good enough for, let's say, a journalist such as yourself to understand what the law is about. Then obviously it gets more technical. It speaks about how each stakeholder is impacted, which may not be of immediate relevance or interest to you. What we've tried doing is to ensure that if it is a larger audience who just wants to understand how the ecosystem works, the initial part of the book is good. But of course, as you want to understand specifically, because what we've tried doing is we are ensuring that each chapter can also be taken as a standalone. If suppose you are a promoter who is having a company which might be getting into the NCLT or has some difficulty, not able to understand, you want to get a complete 360-degree overview or a bird's eye view. So then there is a chapter for that. Similarly for a banker, similarly for a trade credit, so on and so forth. So yeah, I think the initial parts would be beneficial for you to understand, and that's the reason we always call in this book, this is one of the testimonials also that we see, that this book is not a legal book alone. It's a convergence of law, economics, and commerce.
Mr. Anand, let me hold your book once more for the audience and the readers. I hope this book reaches to more readers like me so that they could understand what basically IBC is. Thank you very much for talking to me, Mr. Anand. Please subscribe to our channel Reportage and press the bell icon to remain updated.